This Honorable Court of Appeals of Tennessee is now in session.
Good afternoon and welcome to the Tennessee Court of Appeals. We appreciate you participating in this oral argument via Zoom. We believe that it's the best way to keep the cases moving in this strange time we're living. A couple of things I want to touch on before we get started. First of all, we do not anticipate any technological problems, but if any develop, everybody just sit tight, remain calm, we'll get it fixed. And I promise it won't prejudice anybody in this oral argument. Second thing is, even though we're doing this virtually, the same rules and procedures apply as if we were all standing in the courtroom together today. So essentially, each side gets 15 minutes to make its oral argument. If you're the appellant and you've reserved rebuttal time with the clerk previously, you'll receive that rebuttal time. Before we get started, I want to be sure and introduce our panel for this afternoon. We have Judge Arnold Golden from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Mr. Hibner, anything we need to take up before we get started?
No, Your Honor.
All right, you may call the case, please.
Charles Biggs et al. Versus Town of Nolensville.
And we will hear from the appellant.
Thank you very much. Ben Rabin of the Nashville Bar for the plaintiff appellants, Charles and Gina Biggs, and I've reserved 4 minutes for rebuttal. This is essentially a premises liability slip and fall case involving the GTLA in that there is a municipal defendant. The very short story is our primary client, Mr. Biggs, was walking at night. There was, I think, a 4th of July fireworks show. It's pretty dark. He's walking kind of down a sidewalk and there's some people on the sidewalk, and he essentially takes a step just outside the sidewalk and falls down a steep 8-foot embankment and gets serious injury to his leg. And so we sued the town of Nolensville, and kind of the dispositive questions in this appeal regard whether or not there is immunity for the town, which turns on if there was a dangerous or defective condition, and whether the town had actual constructive notice of such condition. The trial court, this case was resolved by a grant of summary judgment by the trial court, kind of on 2 separate issues. First of all, the trial court held that the town only has a duty to guard against injuries of somebody using reasonable care, and that in this case, essentially the plaintiff wasn't using reasonable care. And second, the trial court held that even if there was a dangerous condition, the town did not have notice of it because there had been no complaints made and they had made periodic inspections, essentially. So addressing those issues, first of all, as far as whether there was a dangerous condition and kind of the issue reached by the trial court, did the plaintiff exercise reasonable care? The trial court basically made a conclusory assertion that taking the step off of the sidewalk was not reasonable, and that sort of ended the analysis for the trial court. We think that that's misguided as a matter of law. For 2 reasons. One, sort of as a matter of law, with that conclusory point, the trial court basically is saying that anytime somebody takes a step off a sidewalk, that's not reasonable. And a defendant can essentially never be liable, regardless of how dangerous the condition could be. And there's just simply no case that says that. The bulk of the case law says that cases should be decided by, when there's contested facts, should be decided by a fact finder at trial. And there haven't been any cases cited by either side or the trial court that says that just merely taking a step off of the sidewalk is inherently unreasonable. And again, our position is that is something that should be decided at a trial. Moreover, in this case, we submitted an expert affidavit that specifically opined to that expert's level of expertise that it was not unreasonable in this situation. Again, we're dealing with summary judgment, and under the summary judgment standards, the moving party, has to negate an essential element of the plaintiff's case, or show that there's no evidence that a reasonable fact finder could use to rule in our favor in this situation. And then the case law says that that can be sort of overcome by the non-moving party with evidence, including expert affidavits. And that's exactly what we've done. So we've completely met the standard involved in summary judgment by presenting an expert affidavit saying that he did not act unreasonably in the situation. So at a minimum, there is a genuine issue of material fact on that point.
What did the trial court, or what findings did the trial court make regarding your expert affidavit?
And that's what's sort of unusual and a little bit concerning to us in this case. The trial court opinion did not address our expert affidavit at all. There is no mention of it, including in the conclusions of law. The court did not say that our expert was wrong or misguided or anything of that nature. Basically, it's like we hadn't even submitted it. I think it could almost be called into question if the trial court was even aware that we had done that. Of course, it was in our briefing to the trial court. I mean, that was our whole argument, just like on appeal, essentially. And the trial court just completely overlooked it, frankly, on both issues. And so there's an appeal that I cited where the trial court had kind of distinguished the expert's affidavit, said maybe it was wrong or didn't apply in this case. And here the trial court didn't even do that. So our position is that the trial court, just completely misapplied the standard by not recognizing the affidavit and not giving it the weight that it should have, to the extent that there's a genuine issue of material fact on that issue.
Are there any disputed material facts in this case?
My position, I think that the town is saying that it was not dangerous and defective. The town is saying that, that it was unreasonable for him to step off. So that to that extent, I think there are issues that are in dispute, that the town does not agree with our expert, I guess, on those points.
I understand there are issues, but are there disputes of fact?
I think they're more the conclusions. I think we all agree he took a step off the sidewalk, he fell, he was injured. The sidewalk itself is not in dispute. So I think it's really the conclusion, the sort of almost the legal conclusions of, was the condition dangerous? Should he have stepped off? Those types of things. So there's not a factual dispute about what happened. It's more those kind of conclusions that are in dispute. That the town's, employees, the city engineer, and another witness, kind of opine one thing, and then our expert says, no, he acted reasonably, the condition was dangerous, they should have noticed it. So it's really more, I think, kind of the conclusions about the facts that are in dispute, essentially. Does that answer your Honor's question?
Yes, thank you.
Okay. So I think, again, at the end of the day, our argument on that with respect to that issue is we have an expert affidavit that's certainly plausible and reasonable, that we think is sufficient to win at trial, essentially, that he was not acting reasonable, and that overcomes the trial court's grant of summary judgment with respect to that issue. With respect to the other issue regarding notice, kind of a similar issue there. The town basically relies on their employees essentially saying we didn't get any complaints, we inspected it looked fine to us, and then our expert said that one, it is defective, and two, they should have noticed that from regular inspections. So we don't necessarily have a reason to dispute that they may have looked at those at the condition at some point since 2012 when it was constructed, but that doesn't necessarily mean that they reasonably looked at it. So I think that's kind of the issue. Did they make a reasonable inspection? And again, we have an expert opinion who says that if they actually reasonably inspected it, they should have realized it was defective. Again, the trial court did not make any mention of that. And again, under our view of the summary judgment standard, that dispute of should they have noticed it, were they on constructive notice, which kind of gets to the issue of was it defective in the first place, is a genuine issue of material fact. We say it is, they say it's not, and that's exactly why we should have a trial on it, essentially. And the trial court simply overlooked completely the affidavit, and similarly kind of did not view these things in the light most favorable to us, and instead basically just relied on everything that the defendant's witnesses said without giving that the proper weight from the summary judgment standard. So it's pretty much our position that just under the summary judgment standard, the expert affidavit should have sufficed on all issues to show that there are, to the extent that the defendant claims that it was defective, that our client acted unreasonably, that basically says the opposite. And that's a classic situation where summary judgment should not be granted. And so the final issue that we have raised essentially is if the court agrees, if the court reverses on summary judgment, of course, the case would be remanded, and we're asking that the court be assigned to a different judge for a couple of reasons. First of all, it's important to note that since it's a GTLA case, it would be a bench trial, not a jury trial. And so the same judge that basically, in our view, completely misapplied the standard and appears to have kind of come to its own opinion about the merits of the case prematurely, it just seems inappropriate to kind of remand to the same judge who has made what we find to be kind of significant errors in the analysis up until this point. I'd note that the town did not dispute that, or I guess argue against that in its response brief. So I'm not sure if that means that they are kind of don't have a position on it, or at the very least have waived that issue. So I think to the extent that, for the court to analyze that issue, I think that is one way this court can address that and simply say that the town has not disputed that. And so again, assuming the court reverses summary judgment, I think the court can simply say that the town does not challenge that request on our part to have it assigned to a different judge. But certainly looking at that standard, we've cited some law going through factors that are considered. This court has the inherent authority to reassign a case. There's factors about the appearance of justice is one of those that we've kind of focused on. And again, our view is that given the way that the court did this analysis and has kind of appeared to have shown it's made up its mind and has, in our view, really misapplied the standards, to then reassign the case for a bench trial in front of that same judge, I think a reasonable person could say that does not kind of meet an appearance of justice and fairness to our client. And one of the factors looks at if there's going to be undue waste or duplication, and that would not be a concern here because there's been no other motions or evidentiary issues. The court, other than just looking at this motion for summary judgment, has no special knowledge that another judge coming to the case would not have. So there really wouldn't be any kind of detriment to the moving along of the case for it to be reassigned. I see that I've run out of time here unless the court has any additional questions at this time.
I see none. Thank you. We will hear from the appellee.
Good afternoon, Your Honor. Sarah Matthews on behalf of the town of Nolensville. As Mr. Rayburn said, it's pretty quick and easy, so I'm sure I will not take up my full 15 minutes and we can all get out of here a little early. The main issue in this matter is whether or not the town had notice, and it falls on constructive notice, like Mr. Rayburn said. The trial court actually found in its memorandum and order that the town retained its immunity under the GTLA because the plaintiffs were unable to set forth proof that the town had notice of a dangerous or defective condition. Now, the town obviously agrees with the holding of the trial court, and we are asking this court to uphold that decision. We do feel there are a few facts that need to be pointed out in this matter, and they more so go to Mr. Biggs, the matter of whether or not he was acting reasonable. And those are, Mr. Biggs had never been to Nolensville, and he had never been to this area, this exact area of Nolensville on the sidewalk in question. He was leaving an event and trying to catch up with a friend, and admitted that he was walking, fast to catch up with a friend. And that when he saw a group of people on an L shape in the sidewalk, he decided to get off the sidewalk and go around them, even though he was unfamiliar with the area and had never been there before. Finally, he also testified that when getting off of the sidewalk, he was actually looking across the street towards his friend and not at the ground where he was walking. So those are just a few facts the town feels are important with regards to whether or not Mr. Biggs was acting reasonable.
Would that go to comparative fault?
Go ahead.
That would go to comparative fault in this matter. Yes, sir.
Okay, thank you.
So tell me what the trial court did with the affidavit that the plaintiff submitted.
Well, I was at the oral argument for the motion for summary judgment. We didn't discuss it. It never came up in our oral arguments. It was in the plaintiff's brief, and it was not included in her memorandum and order.
you're not saying that it wasn't submitted to the court for consideration, are you?
It was submitted to the court.
Okay, so we've got a affidavit from an expert at a summary judgment hearing. What do you do with that?
I mean, honestly, in my opinion, they were pretty bare, conclusive opinions from the expert. He said the sidewalk was dangerous, but he didn't say why the sidewalk was dangerous. And we felt like we set forth facts establishing that the sidewalk wasn't dangerous and defective. And even if it was, the town did exercise that reasonable skill and care in performing periodic inspections, visual inspections of all the sidewalks in Nolensville. And we submitted an affidavit from our public works director who also stated they have never had any issues with that area. They performed these visual inspections and never noticed a dangerous condition.
Well, don't you have competing evidence here regarding the condition of the sidewalk and how reasonable things are? Can you actually determine that at a summary judgment hearing?
I mean, my opinion was that they were just very bare conclusions and that the town set forth facts that showed that we didn't have notice.
I don't think you answered my question. Is that proper for a determination at summary judgment?
It would likely not be proper.
Okay, thank you.
You're welcome. So going on to the issue of constructive notice, because I do not believe we have any disputes on the fact that the town did not have actual notice. There are three ways in which the plaintiff could show constructive notice. And the way the plaintiff is attempting to show that is by showing that the condition existed for such a length of time that the town, in the exercise of reasonable care, should have noticed the alleged dangerous or defective condition. As the plaintiff has stated, and we just discussed, they did submit this expert affidavit. In our opinion, it's just a very bare conclusion that it was dangerous or defective. However, we believe that the town provided proof that showed, and they failed to dispute, how long that dangerous or defective condition existed, and two, any facts that would dispute that the town exercised reasonable care. And in fact, we did exercise reasonable care in performing these inspections and ensuring that all the streets and sidewalks in Nolensville were in a safe and reasonable condition. Under, I think it's in the Hawks case, the court says that you can find constructive notice where a dangerous condition could have been discovered by reasonable diligence, and a governmental entity has a duty to exercise such diligence. We feel that we have fulfilled that duty in performing these visual inspections and completing repairs when necessary or required.
Was it the sidewalk itself? My understanding is it was the gradation off the sidewalk that was actually the issue here, that's what the dangerous condition was, that there was never, I didn't understand that there was any issue with the sidewalk itself, but
Yeah.
off the sidewalk.
Yeah, it's more so the area next to the sidewalk. And our city employees, I believe it was our town engineer, went out about a year after the accident when we received notice of the lawsuit. And they did a measurement of that area. And the slope, we described it as a gentle slope because over a 2-foot area, it declined about 4 inches. And so we kind of compared that to the Hutter case, in which the court said a 3 to 4 inch drop off from the street to the sidewalk wasn't a dangerous or defective condition. So when our employees go out and they're doing these inspections, they're not just looking at the sidewalk, they're obviously checking all of the areas nearby because, like you said, it's the sidewalk and then the area adjacent to it. And then there's a drainage ditch down from the sidewalk. So not to be repetitive, but as I just said, the town feels like it performed its reasonable due diligence and conducted inspections routinely, performed repairs when necessary, relied heavily on complaints of citizens and reports of injuries, and they had just never received any of those. With regards to Mr. Biggs' reasonableness, I know the judge did in her memorandum state that Mr. Biggs was not acting reasonable. However, at the end, she held that the reason she found for the summary judgment was because there was no notice, not because he was acting unreasonable under the situation. But as I stated the facts at the beginning of the case, Mr. Biggs had never been to this area before. It was dark. He chose to get off the sidewalk instead of saying, "Excuse me," to get through the crowd of people, or to simply wait until that crowd cleared. We feel that if he would have been exercising reasonable care by waiting or saying, "Excuse me," he would not have been injured. Honestly, we would just ask that this court uphold the decision of the trial court and find that the town retained its immunity under the GTLA.
Thank you. We will hear from the appellant in rebuttal.
For our clock to get reset.
There we go.
All right. Yes, sir. I just wanted to address a couple brief remarks, I guess. First of all, as far as our experts report and affidavit, I would certainly dispute that he made, just kind of a conclusory statement that it was, oh, it was dangerous and left it at that. Certainly, if that was the case, I agree that wouldn't be enough to overcome summary judgment. But I think it's about 30 pages in the record between pictures. There's an affidavit. There's a report. I think it starts at about page 99 in the trial court record. And so I'd certainly invite the court to look at that and make up its own mind. It is a de novo standard of review here. And in my view, it's very detailed, gives, pretty exhaustive reasoning about national standards of kind of what's accepted for how to, properly mark things for public right of ways such as this. There's photos in particular. I think page 120 of the record kind of shows that grade where it does initially start to drop a little bit softer, but then it does, significantly drop after that. And so we look at that collectively. It doesn't just stop right there in the first foot. It drops off significantly, and that's exactly what happened to Mr. Biggs. He fell down the whole thing. So if all it did was drop a few inches and stop and level out, that would be one thing, but it's a continuous drop, which is exactly what he fell down. And significantly, kind of getting to his reasonableness, one of the things that I learned from the report was about standards regarding crosswalk markers. And there's a picture of that on page 120, where basically in the street, there's the crosswalk lines to indicate to motorists that that's a crosswalk. And those lines are supposed to be the same width as the crosswalk to create a visual cue to know how wide the crosswalk is, or the sidewalk is going to be. And here the markers in the road, those crosswalk lines, were wider than the sidewalk was, which our expert kind of concluded what kind of could sort of induce somebody to think, or make somebody think that that's going to be the expected width of kind of the safe area when you get across the street. So that's part of why our expert opined that our client was not acting unreasonably, because of the visual cues that people expect to see were not present. Certainly there was no barriers or tape or anything else to actually physically keep somebody from going that way. But even the visual cues, if anything, actually almost kind of enticed people to think that it was safe to go further out, which in large part in this case, it was, I don't know if we've mentioned this during our argument, but it was very dark. One of the issues that we briefed more below that didn't really come up in the trial court's ruling that we haven't gotten too much into, it was very dark at the time. There was a kind of a street light that was out. And so it wasn't just broad daylight where he could have easily seen if he looked down. Part of the issue is that it was dark and he couldn't have seen it, which is why our expert opined that condition, particularly at nighttime when it was dark, was particularly dangerous, and which is why the town should have, if it was going to maintain a condition like that off the to the embankment, to have more visual cues, barriers, a number of things that would have been feasible and that are consistent with national standards. And again, there's pictures of all of that in the record that the court can certainly review. It is a de novo standard, and I think it kind of illustrates all of these things a little bit more to actually see those pictures. And so those are kind of the points that I wanted to respond to, unless the court has any additional questions.
I see none. Thank you for your argument. We appreciate it. We will take this matter under advisement and attempt to render an opinion at the earliest possible time. We again appreciate you participating via Zoom. Ms. Tibner, if there's nothing further, you may recess court for the day.
This honorable court is now adjourned.